But on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision on whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. Be that as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether this is as Malane Senior on the Muite has anything to add.
My lords, your leadership, we appreciate that this honorable court of its own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client, but it is for the client to make the final decision. But in fairness to me as counsel, another counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this court. It is damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this court by the Court of Appeal. It was a very unfair position.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. The respondents support a fair resolution of this dispute in accordance with the law, and therefore we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kibe Mungai, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. We thank you.
My Lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024, and I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to, immediately after this. I'm most glad.
My lords and your leadership, further to that, for Senate, I wish to state, my lords and your leadership, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is it the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Kibe has talked about the gallery of Paul Muite Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to engage? Do we need to engage in arguments on that?
Let us not go into that now.
I will withdraw that. But my lord, we are ready to proceed.
We don't want to address something and then you say you withdraw it. You don't have to forcing the damage. We withdraw properly.
I will withdraw the remark that the petitioners are addressing the public gallery today.
My lord, with your permission, my lady, yesterday we were barred from being part of these proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you.
In which petition? In which petition?
Lord, there is petition 5 E570, E550, E541, E572 that are supposed to be before you. That we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly, let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Muite, and the ones made by my learned friend, senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my learned friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequently to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which your lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My lords, may it please you, I hate to interrupt, but this is most unprocedural. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
If I may, my lord. There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Yeah, you have talked about counsel on this side we have.
Yes.
Counsel on that side appears to be taking the whole of it.
Because they stand back.
Please,
Just speak, Mr. Muite. If you want to be heard, just speak.
well, I'm asking
Yes.
of equity of court time to counsel on this side.
They stand and speak. You also just stand and speak. We are not
My lord, my lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling we've read, the question that we wanted was the application for the validity, plus the issue to do with the recusal we had together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, I shouldn't know about it, 3 applications for recusal. Those are preliminary issues, and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition had as of yesterday. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number 1. Issue number two, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates, led by my colleague, Ms. Kimoko, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situation where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the information of that.
Your Lordship, that I had just wanted to highlight the content of the notice which you received.
I think let's talk about the notice. I said, Your Lordship, we will talk about that notice.
Your Lordship,
I will talk about that notice before you speak.
My Lord, do I have your permission to address the court?
Yeah, even if the court wants to talk, you don't want the court to talk. Dr. Khaminwa, let me address the issue.
Oh, I'm sorry. I apologize. Sorry. I apologize.
I think we have made it very clear in the ruling which I have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first, then from there you see the directions emerging, and then you can make your prayers. Let's mention these files first. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in Parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed. And with you, we consolidated all those petitions yesterday. So we have 2 running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you would be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number, let's mention petition number 570 of 2024, AD by Uhuru and Victor Gatia. Yes, this petition.
Yes. My Lord,
Yes. Yes.
My Lord, in this petition, this one was filed by the law firm of, I believe, Mutembei, and it's called what? Mutembei, Geshoro, and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him.
Alongside who?
Mr. Mutembei Marete. My Lord, the parties are many, starting with the first respondent against President Ruto, regarding Gachagua in the second respondent, and there are others. My Lord, for purposes of this petition, it was filed on Friday, and by Judge Mamuye, referred it to the Honorable Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembei was not served with this particular notice that is before you.
Actually, nobody was served. We sent out the notice in the morning today because we received them in the morning. And that's why I said that this matter will come in.
Yes.
And because the representation is likely to be approached, we mentioned them because we thought we'd find people like you waiting for them.
Waiting for them here.
Yes.
So that, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter, the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, would have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow, so that the issue on that issues of empanelment and in the presence of Mr. Mutembei can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file. We are just looking at it from our record. But that is the position as far as 570 is concerned. There is a specific application for a 5-judge bench in that matter.
Mr. Kibe.
Yes, my lord.
We are beyond that. There was a request for a 5-judge bench.
Yes, my lord.
But what has been empaneled is a 3-judge bench,
yes,
comprising Justice El Kugola, Justice Ndegwa, and Honorable Dr. Justice Freda Mungai. So the request for a 5-judge bench, I think, is overtaken by bench and stay unless he wants to appeal.
Yes. The chances of appeal are very high. So for the simple reason, my lord, that will become apparent, I believe there must be some mechanical applications to the issues, but right specifically, that issue would be addressed, and the Chief Justice would have the relevant communications tomorrow morning, while given the nature of the issue that must be dealt with, there must be a 5-judge matter. All benches can be expanded. I believe that is the positions that we are coming from. So without saying specifically that we don't want anyone, all benches are capable of being expansion, particularly bearing in mind, and this is something that a number of the clients that already we are representing, there have been repeated insinuations by our people out there, including Senior Counsel Abdel Abdullahi, that the senior bench is supposed, 3-judge bench is supposed to do this or the other. We can't help that. This is not coming from the petition.
What we'll do in some way is that we'll mention this matter tomorrow.
I'll appreciate. What time, my lord?
At 9.
Most obliged.
Mr. Kibe, you will serve.
Most of the people actually here, we had served them, but we shall serve the notice of hearing.
All right.
The notice of hearing for the mention tomorrow at 9. I thought, my lord, the time would have been easier, because by the time I go to my office, there will be nobody to do some of this. Or probably left.
You know, by the time we spend here means that even if you come at 10, you'll find us here.
And at what time then do we come tomorrow?
The court starts at 9.
Yes.
You can come at 11.
11. What's right?
But I am asking in this particular file that you record my presence together with the other lawyers I mentioned earlier as appearing for the Deputy President with the second respondent.
This one?
Yes.
The verified?
Yes.
But you didn't stand up in Muite. I thought you were not here.
Patiently wait.
This matter of 570?
Yes. If you look at the package, the Deputy President is the second respondent.
So you agree with the directions which you have given?
I accept the directions. And I will be here tomorrow at 11. Inshallah.
This particular matter.
Let's the same matter.
Yes.
570.
Yes, my name is Manzo. I wish to go on record for the first interested party.
Your Lordship, my lady, may I be placed on record for the second and the fourth interested party? And permit me to only indicate the implication of the orders of the Parliament that were issued by the judge who directed the Chief Justice does empanel you. To the best of my thinking and knowledge is that the prayer was granted as it is for the empanelment of 5-judge bench.
Mr. Njiru, Njiru, yes.
They want Njiru.
We speak from the record. You had me mention the parties. I said that this file has been empaneled to comprise the Honorable Mr. Justice Eric Ogola, the Honorable Mr. Justice Murima, the Honorable Dr. Judge Freda Mugambi. I think that's very clear. We are only three.
That's correct. But I will address it more on that issue.
My lords, my lady. So we mention it tomorrow. Mr. Njiru, you say you come for which parties?
You know, I am here for the second and the fourth interested party.
Thank you.
My Lord, perhaps if I may make a request. My Lord, there is a file that is live before you. And that is petition number 565 of 2024. We have requested, my Lord, that you give directions in respect of the applications in that matter, because this process of taking quorum might take some time. And there are 3 cohorts of files that are before you. And if I may just be given a moment to explain myself. As the court has correctly identified, there is a cohort of files that are consolidated in petition 522. There is a cohort of files that is consolidated around petition 565, which have the 2 applications that the court has identified as urgent. And then there are these others that have been referred to the court by virtue of the email that we have all seen today. It is my request that the court keeps them in those cohorts so that these are important, but the applications are urgent. And the court has identified that urgency, because this will go on for 2 or 3 hours without any directions having been given in 565.
Lord, could we be on board together? We are being made orphans. The state is in the bedroom. Let us also be in the bedroom so that we can respond.
What do you want to do in the bedroom?
We will discuss. And we allow the parties to come on record.
Mr. Demodi, the reason why we are mentioning these matters is to find out if any of them would be right for consolidation with the matter which is here, so that we don't duplicate.
Thank you, my Lord.
My Lord, perhaps as you consider that, let me put it on record that if you are considering whether they are right for consolidation, the consolidation should not then slow down the hearing of the application that you have already identified as urgent. If they are to come on board, they come on board and proceed from where we are.
Let us be on board first. We respond to you appropriately. Allow us, even the LSK former president, to be on record.
My lady and my lords, I just have a passionate plea to make. There are not many pleas. The first plea is we consider utilizing the ceremonial court to the ground floor because it is spacious. It's sufficient for all of us. That's number one. Number two, my request is this. The court has all the petitions. Why can't the assistants to the court enumerate the parties there in the quorum in the manner we used to do in the Court of Appeal before? So that when we appear here, whatever time we indicate, we'll just fill our respective names and the court will be able to deal with the matter without the need of this back and forth. Number three, my lords and my ladies, I think the court needs to just be a little bit proactive. When you retreat, you may make 2 decisions. One, either to determine the interlocutory applications, in which case you can frame issues for the parties to submit them. Or 2, if you're minded to hear the petitions themselves, then still frame the issues and forward it to us so that we're able to make progress. That way we make good use of the judicial time that is very limited in this particular. I beseech you more.
Thank you, Mr. Harvey. Well taken.
As a former chairman of the Council of Science, let me second the first issue and plead that if only for the purposes of everybody getting sufficient oxygen, as we are too crowded, and the people want to listen, and the media, and the members of the public, if it is possible, let us use the ceremonial hall.
Council, Senior Council, we will use the ceremonial hall as from tomorrow.
Thank you.
And
I wish to say that perhaps when giving directions, then until parties, files are going to be consolidated, then it will be proper each person is served with the application so that we are able to respond, even if we are given a day to respond, so that when we begin to submit, we are able to submit according to the law, not as per the bar and whatever issues are being raised. Thank you.
Thank you.
My Lord, I was going to beseech the court, if we are to make progress, I beseech the court to invoke its powers under Section 55, Article 159, we go on and on. There is no shortage of legal provisions enabling this court to rein in on the lawyers. Because if you don't do that, my Lord, on a matter like this, where you're 20 lawyers, 50 lawyers on the other side, we will be coming to you, we'll be doing legal gymnastics, legal ping pong, what I call legal sophistry on other occasions, and meanwhile we'll be lamenting as we are now lamenting to you. So there are applications, both from this side and this side, certified agent. Meanwhile, we are spending a lot of time, each of us from whatever side, starting to raise this or other housekeeping issue. I beseech you, my Lord, in a matter like this, the court must be very firm. It must rein the council. The court itself must have very clear direction. Which is the application that will be had, in what sequence, what are the time allocations, how the parties share those times.
We have agreed on that, and what we ask is let us mention these matters so that we know how they relate to the other matters which are before the court. So we have mentioned 570. We have mentioned we have 570.
My Lord.
We have mentioned 570. There's
570.
This 550. 550.
570.
We have mentioned E570. E550, Speaker of the National Assembly versus Brigadier Chapel.
But this file is already consolidated under the cohort of 550. No, I'm sorry, my lord. That was not.
Yes. 550. Who's in 550? Who is in 550?
My lord, mine is 572.
I'm asking 550.
Yes, my lord, 550. My lord, we appear for the first respondent.
I guess you can tell us who is the application.
The petitioner, my lord, is the former deputy president, my lord. Represented by my lord senior.
My lord, I appear for the deputy president, not former. He remains in office on the basis of the conservatory orders, and each bench has confirmed waiting issues, which is why we are here. Let's not join the rush.
For the first petition,
For the first petition. I thank you.
My lord, if it pleases you, Nyamodi and Gumbo for the second respondent. And our learned colleague, Mr. Muruga.
That matter, my name is Kibe. I have here together with Ms. Angie and my senior Professor Ojienda for the third and fourth response.
Yes.
Who else is in this matter? So, for the petitioner, Mr. What are the issues in this matter? Are they relevant to the consolidated petitions?
There are so many files here.
This is
the same team of lawyers,
yes,
including myself that I gave when we came for the ruling, is appearing for the deputy president.
What I'm asking is it going to be consolidated or is it standalone?
One of the ones that we are consolidated.
No. Sorry if I appear.
Yes, speak, please.
For you to be able to progress, I beseech you to adjourn this matter tomorrow. Go and make directions. You're either hearing the petitions or the applications. Come here so that we have a perspective of what we progress. Otherwise, you will not make.
We are alive of that fact, Mr. Harvey, that
It's my advice.
it is the councils who will be saying that their right to be heard, even on petition, even if the slightest issue has not been granted. Therefore, let us agree on the way forward. If you make a proposal can come from you your side, how you want to deal with all these petitions. Is it possible that you want to ignore all applications and proceed the petitions? You can make a submission which this court can consider.
My Lord, if I may, just to guide the court, and on this account I will bring it as senior counsel. My Lord, there are urgent applications before you. The applicants or the petitioners at their right yesterday on a preliminary objection the court has ruled on this afternoon. My Lord, we have an urgent application that was filed before you, dated 18th October 2024, for discharge of the conservative orders. Whatever decision this court makes can be either way. We need two directions on the hearing of all the consolidated petitions. Some of the petitions, my Lord, deal with issues or causes of action that arose before, my Lord, the impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservative orders. I think, my lord, that's the only way we can move, because they have had their right, let us have our right as well. It will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Ojienda. What I'm saying is that let's mention these files. We are on the third one, and if you have not been interrupting, perhaps we'll be through with them. 550, I've recorded the forum, and what I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone?
Can we deal with that or not more? We only do it. Because I need
because
there's a we only deal with one. Consolidation has implications. I need to consult my team. Let us consult the client. Let's take the quorum. Let's deal with the consolidation too.
So we mention it tomorrow.
Yes, yes.